In this case, the High Court has held bunching of show cause notices for multiple years. Show cause notices cannot be issued for periods extending beyond one financial year, forcing payment of aggregate demands and affecting rights to contest, noting identity theft, directs Aadhaar PAN details deletion. Union of India and others versus Tirth Agro Technology Private Limited for calculating refunds in case of inverted duty structure constitutes sufficient and valid service of notice. As per section 169, the supplier had actually paid the GST was a key factual issue. GST outlook for the week. My dear friends, GST landmark judicial outlook number 1. My dear friends, there is a case pertaining to Madras High Court, RA and Company versus Additional Commissioner of Central Taxes, South Commissionerate, WP number 17239 of 2025. In this case, the High Court has held bunching of show cause notices for multiple years frustrates limitation, amounts to jurisdictional overreach. My dear friends, the facts of the case is the Madras High Court held that issuing a composite show cause notice covering multiple years without separate adjudication for each year violates limitation principles and hinders the assessee's ability to provide year-wise defenses, thus amounting to jurisdictional overreach. It was held by the court that term tax period under the GST law refers to either a monthly or yearly tax period. Show cause notices cannot be issued for periods extending beyond one financial year, rejecting the revenue's argument that the tax period can encompass multiple years. My dear friends, this is a landmark judgment because based on section 2, subsection 106, defining tax period, the show cause notice can be issued based on either monthly or annual returns for the relevant financial years or part thereof. If a return covers multiple financial years is filed, a single show cause notice for those years may be issued. Therefore, show cause notice must be specific to individual years. My dear friends, drawing the analogy from section 128, waiver schemes and compounding provisions under section 138 of the CGST Act, the court emphasized that bundling show cause notices for multiple years causes undue hardship to the assessee, forcing payment of aggregate demands and affecting rights to contest specific years. My dear friends, the court referenced its earlier Titan Industry judgment to underline that composite show cause notices affect the assessee's right to contest issues under section 73, distinctly from offences under section 74. It held that show cause notices must respect limitation safeguards under section 74 subsection 10 and section 136 restricting issuance strictly to one financial year, quashing orders arising from composite notices. It was held by the Madras High Court, my dear friends. GST Judicial Outlook number 2. Bombay High Court, in case of Vilas Prabhakar Land versus UIDAI and others, writ petition number 3586 of 2021, held that decrying authorities' inaction quashes attachment noting identity theft, directs Aadhaar PAN details deletion. My dear friends, the facts of the cases, the Bombay High Court identified that the assessee's Aadhaar and PAN details linked to their trade name were misused by third parties to obtain fraudulent GST registrations, causing significant legal and financial harm to the assessee. The court strongly criticized multiple authorities including UIDAI, police, banks, GST, income tax department for ignoring repeated compliance over 5 years, highlighting a systematic failure to act promptly against identity misuse and fraud. My dear friends, the judgment undercoats statutory obligation under laws like Aadhaar Act and RBI guidelines that mandate authorities to investigate and address complaints of identity misuse, emphasizing the need for proactive enforcement. My dear friends, it was also held that due to the impersonation, the assessee faced wrongful criminal proceedings, property attachment, check dishonor. The court called for accountability of negligent authorities and condemned the non-appearance of key tax officials during the hearing. My dear friends, the court ordered deletion of the fraudulent Aadhaar and PAN links from the GST portal, quashed wrongful property attachment, and imposed cost on defaulting authorities, signaling the judiciary's firm stance on protecting taxpayers' rights and ensuring enforcement efficiency. GST Outlook number 3. It is a case of the Supreme Court. Union of India and others versus Tirth Agro Technology Private Limited, Special Leave Petition Civil Diary number 31632 of 2025. My dear friend, the Supreme Court dismisses Revenue's SLP challenging grant of IDS refund as per modified formula. My dear friends, the facts of the case is the Supreme Court dismissed the special leave petition filed by Revenue against Gujarat High Court's judgment regarding the use of the modified formula under Rule 89 Sub-Rule 5 for calculating refunds in case of inverted duty structure. We call IDS as inverted duty structure. My dear friends, the Gujarat High Court, following its earlier ruling in Ascent Meditech, held that the amended formula under Rule 89 Sub-Rule 5 is clarifactory and curative, therefore applicable retrospectively. My dear friends, the Gujarat High Court found no reason to deviate from its previous decision in Ascent Meditech and accordingly allowed the writ petition filed by the assessee, affirming the retrospective application of the modified formula. My dear friends, the Supreme Court noted that although the present petition was filed in June 2025, the Gujarat High Court did not mention the dismissal of the SLP filed against the Ascent Meditech order, which the High Court had relied upon. My dear friends, this judgment reinforces that the modified formula in Rule 89 Sub-Rule 5 can be applied retrospectively for refund calculation involving inverted duty structure, providing clarity and legal certainty for taxpayers claiming such refunds. GST Judicial Outlook number 4. My dear friends, it is a case of Kerala High Court judgment wherein Latish Kutirumbal versus Central Board of Indirect Taxes and Customs, WP number 16114 of 2025. It was held notices and orders are valid if uploaded on the portal. Notices and orders are valid if uploaded on the portal, even if not served physically by post. It was held by the Kerala High Court judgment. GST Outlook number 5. My dear friends, it is a case of Kerala High Court judgment, Latish Kutirumbal versus Central Board of Indirect Taxes and Customs, WP number 16114 of 2025. It was held notices and orders are valid if uploaded on the portal, even if not served physically by post. It was held by the Kerala High Court. My dear friends, the facts of the case is the assessee was issued a notice to file GST returns and appeared before the concerned officer but failed to submit returns for over 6 months. Due to prolonged non-compliance, the assessee GST registration was ultimately cancelled under the provisions of the CGST Act. My dear friends, the assessee argued that notices and cancellation orders were not physically sent by post to their address, claiming lack of awareness of such notices. The court held that uploading notices on the official GST web portal constitutes sufficient and valid service of notice as per section 169D of CGST Act 2017. My dear friends, the absence of physical postal delivery of notices or orders does not invalidate the proceedings or orders, hence the cancellation order stood upheld without scope for interference. GST Outlook number 6. It is a case of Rajasthan High Court, Malhotra Agro Industries versus Deputy Commissioner, State Goods and Service Tax, Civil Writ Petition number 17270 of 2024. My dear friends, it was held appeal delay beyond 3 months plus 30 days not condonable. Appellate authority lacks power to extend time. Held Rajasthan High Court. My dear friends, the facts of the case is the appellate authority power to condone delay in filing appeal is limited and explicitly governed by the provisions of section 107 subsection 4 of the CGST Act. Appeals filed beyond the prescribed limitation period, 3 months plus an additional 30 days cannot be condoned by the appellate authority. My dear friends, section 5 of the Limitation Act, which allows for condonation of delay, does not apply to GST appeals under section 107 subsection 4 as the latter's language is clear and unambiguous. My dear friends, appeals delayed beyond the maximum permissible extension, 3 months plus 30 days, are rightly dismissed as time barred without legal error. My dear friends, it was held in the Supreme Court. The Supreme Court has consistently upheld that appellate authorities lack the jurisdiction to condone delays beyond prescribed 3 months plus 30 days limit, affirming the validity of such dismissals. My dear friends, this is a landmark judgment with respect to condonation of delay. GST Judicial Outlook number 7. It is a case of Allahabad High Court, New Goyal Beach Bandar vs. Assistant Commissioner, writ tax number 2487 of 2025. My dear friends, it was held that determination of tax liability on deceased without show cause notice to their legal heir unsustainable was held by Allahabad High Court. My dear friends, the facts of the case is Section 93 addresses liability for tax. Section 93 of CGST Act addresses liability for tax. Same is the case of SGST. Section 93 addresses liability for tax, interest or penalty when a business continues after the proprietor's death by the legal representative or is discontinued. But it does not authorize making tax determination against the deceased person directly. Accordingly, my dear friends, issuing a show cause notice and making a demand in the name of the deceased proprietor or firm without involving the legal representative renders the proceeding void ab initio, invalid from the outset. My dear friends, for liability to arise post death, a show cause notice must be issued to the legal representative, who must be given an opportunity to respond before any determination is made. My dear friends, liability for tax penalty after death can only be imposed on the legal representative following proper notice and procedure, ensuring due process of law is followed or observed. My dear friends, in cases where notice and determination are wrongly made against the deceased without involving the legal representative, courts will quash such orders, allowing the tax authorities to initiate fresh proceedings in compliance with legal requirements. GST Outlook number 8. My dear friends, it was held in Calcutta High Court. Shamal May Paul vs. Assistant Commissioner of State Tax, WPA number 708 of 2025, that ITC, that is input tax credit, can't be denied just because supplier's registration was cancelled with retrospective effect. My dear friends, the facts of the case is the petitioner assessee claimed input tax credit for supplies made by a supplier whose GST registration was later called cancelled retrospectively. It was undisputed that the supplier's registration was valid at the time the supply was made. My dear friends, whether the supplier complied with GST provisions, including timely payment of tax and duty, is crucial to determine the assessee's entitlement to ITC, that is input tax credit. Both the adjudicating authority and appellate authority failed to examine or rule on whether the supplier had fulfilled GST obligation necessary for the assessee to claim input tax credit. The question of whether, my dear friends, the supplier had actually paid the GST was a key factual issue that was overlooked, impacting the determination of ineligible input tax credit. My dear friends, because critical factual and legal determinations were not made, the orders denying ITC and imposing interest and penalties were quashed by the reviewing authority. That's all for the day. Signing off, Advocate Dr. M. Satyakumar. Thank you.